Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Our topic today, contracting for artificial intelligence in the evolving regulatory landscape. Companies in most industries are actively pursuing and seeking to scale existing implementation of artificial intelligence, or AI, solutions to increase revenue, cut costs, develop new product offerings, and remain at or gain a competitive advantage. To realize the potential benefits of AI solutions, companies need to evaluate and account for related regulatory and compliance risks. So today we're going to talk about some of the key practical and legal considerations that companies should keep in mind when they're evaluating, licensing, and implementing AI tools. My name is Julian Dibbell, and I'm your host. I am a senior associate in Mayor Brown's Chicago office with a practice focusing on technology transactions. Our guests today are my colleagues Vivek Mohan and Marina Aronchik. Vivek is a partner in our cybersecurity and data privacy practice in Northern California, recently joining us from Apple, where he was a senior attorney on the company's global privacy law and policy team and head of information security law. Marina Aronchik is a partner in our technology transactions practice. Marina is based out of our Chicago office. Marina, Vivek, thank you for joining us today.
Happy to be here. Thanks, Julian.
Pleasure to be here.
Great. In one of our earlier episodes last year, we talked about AI licensing, what the organizations need to consider when licensing AI. In that episode, we talked about the fundamentals of AI. That is, at the most basic level, what is AI? It's software that can perform tasks normally done by humans. At the time, we talked about broad categories of AI solutions: machine learning, deep learning, which is a subset of machine learning, and robotic process automation, or RPA. This last category, RPA, these are essentially bots, pieces of software that perform routine and repetitive tasks from automation. Are these, so machine learning, deep learning, and RPA, are these still the main types of AI solutions, or are we seeing something different in the market, Marina?
Thanks, Julian. And yes, I think those are still the main categories. One of the things that we're seeing, though, is what I call all AI is software, but not all software is AI. By that, I mean that on-prem and cloud software is increasingly labeled as AI for marketing purposes based on the broad appeal of AI. But not all of those tools raise unique concerns that are relevant to AI. And conversely, some tools that are not labeled as AI do raise those unique issues. The way to look at it is that AI is an ecosystem. It consists of numerous pieces of software, tools, and technology that include various elements of AI or services like professional services related to machine learning, deep learning, and the various tools and offerings that support that. To determine whether a tool that a company has or is considering to license is a true AI tool that raises the types of issues that we're calling AI, you need to investigate its functionality and determine whether it contains machine learning components.
Okay, so why are we singling out machine learning here?
Well, machine learning means that you're dealing with a tool where an algorithm produces results when it's combined with data. This is the opposite of traditional software, where we have a developer transforming existing decision-making into code and then compiling that to produce the output. So the question to ask when you're dealing with machine learning is the following. Is this tool designed around an algorithm that either exists today or that will be created and that will then be applied to data in order to create an outcome that's not known today? Or put another way, is this a tool that will be fed data to train its ability to make predictions, decisions, and recommendations? And it's this ability that concerns or may concern the regulators and that raises potential compliance issues.
Okay, understood. So, Vivek, is there then existing regulatory guidance that addresses these kind of true AI solutions? Again, not the machine learning type of things. We're not talking here about RPA and kind of scripted bots. We're talking about these learning types of AI. So how do the regulators conceptualize AI in this context, and what's their views?
So at a high level, regulators are just starting to define AI. The framework that's in place today has really evolved out of the existing laws in privacy, data protection, and anti-discrimination. And we've seen a lot of efforts, including in the US, dating back to the Obama administration, to draw a more defined circle about what constitutes AI and what doesn't. But at the moment, there isn't a formal legal definition that can be broadly applied.
Okay, so sounds like, as promised, we are dealing with an evolving legal and regulatory framework, and that we can safely assume that there is more to come. Yet companies are rapidly adopting AI. Look at a recent McKinsey survey for 2020 saying that overall, half of their respondents have said that their organizations have adopted AI in at least one function, with service operations, product or service development, and marketing and sales at the top of the list. And certainly we are increasingly working on deals focused on AI or involving AI as a component. Marina, I assume you deal with these compliance and regulatory issues in these transactions. Could you speak to that?
Absolutely, and these are thorny issues. At the fundamental level, the premise that you cannot outsource compliance remains true with AI licenses. The company's use of AI logic, AI-based decisions must still satisfy the same laws and regulations that apply to decisions that are made by humans. That said, one key issue in AI licenses is allocation of compliance responsibility. How to allocate compliance depends on which party understands and can implement that compliance. Here, again, understanding the specifics of what you're licensing is key. If we think about AI logic, this logic is created based on an algorithm in the tool using training data and then further refined using production data. If that AI logic ends up discriminating in an unlawful manner, which party should be responsible? And the answer is it depends. If this logic is trained based on a combination of customer data, suppliers' own data, and the data of many other customers, it would make sense for the supplier to take on the compliance function for all customers and reflect that in the cost in service pricing. But on the other hand, if a customer is hosting that solution and training it based on that customer's own data, it would probably be best for customer to keep the compliance responsibility.
Okay, so assuming the parties have worked through these issues in the agreement, is there anything in addition to that that our clients should be considering, whether at the operational or overall compliance levels?
Yes, I think before or in parallel with the contracting stage, and as part of an ongoing effort, the company really needs to determine whether the use of the particular AI tool is appropriate. Let me give you a couple of examples here. First, let's look at bias and discrimination. Here, the concerns may range from use of AI together with facial recognition software to lead to discriminatory outcomes, or if we think of financial institutions, bias and discrimination in lending decisions, for example. Another example is antitrust. There is significant concern among some regulators that AI tools can be used to, whether directly or indirectly, facilitate price fixing arrangements among competitors and to reach anti-competitive agreements. And here, note that we're not just talking about the use of the tool by a single company, but it could be much more complicated, where use of the same tool by several companies in the same industry, knowingly or unknowingly, through training data, could result in the creation of an anti-competitive algorithm. These issues may result in compliance problems where contractual allocation of risk certainly matters, but companies also need to address early and often ESG type issues and reputational and PR issues, so-called value misalignment, where public and reputational harm, rather than what we view as purely legal, and claims of bias in tools you use could create significant risks.
Vivek, Marina mentioned discrimination concerns, antitrust. Obviously, this is getting us into the realm of regulatory issues. What do you see as the regulatory landscape for AI solutions?
There's actually been a flurry of recent guidance, including proposed regulations around the use of AI. In the US, the Federal Trade Commission, or FTC, in April alone put out two lengthy pieces that outline their views on the use of AI and algorithms, and that encourage companies, guide companies on how to aim for, and I quote, truth, equity, and fairness in your company's use of AI. Before I jump to Europe, which has been maybe the more notable development, it bears note that there's no AI regulator at the federal level. The FTC has used its traditional Section 5 authority over unfair and deceptive acts and practices to expand over time into our de facto federal privacy and security regulator. And with this advancement, they've increasingly embraced their role as a broader regulator of technology writ large. Notably, at least for the moment, this expanded conception of its own role does not come with expanded authority. The FTC has been severely circumscribed from enacting regulations and implementing Section 5 since the Magnuson-Moss reforms that date to the 1970s. There are efforts underway at the FTC to consider rulemaking under the onerous processes that are set out by Magnuson-Moss, or MAG-Moss as it's called. And there's, of course, constant discussion on Capitol Hill, but until something happens, and unless you're engaging in regulated activities, such as under the Fair Credit Reporting Act, these blog posts or pieces are just what they seem, blog posts. Instructive, helpful, insightful into the views of the commission, or at the very least commission staff, but they're not binding. There's a lot in there, and I encourage everybody who's listening to this podcast who wants to learn more to take a look. They talk through some of the kind of key high-level concepts around explainability and transparency, fairness, making sure that you have the data that goes into the models that are robust and empirically sound, companies holding themselves accountable. These are just high-level kind of pillars and concepts that the FTC is starting to put some kind of contours around.
Okay, you mentioned Europe now. What's the situation there? Is that different than what we're seeing here in the US?
Yeah, I think that this is maybe much like in the privacy space, we're seeing Europe adopt a more formal approach. So in Europe, one of the core conceptions or expressions of AI, known as automated decision making, especially related to decisions about individuals, has been regulated going back to the Data Protection Directive of the 1990s. The directive, which was replaced by GDPR, which many of our listeners are likely to have spent far too much time getting to know, sets out a governance framework from an individual rights perspective. The individuals have the right not to be subject to a decision which produces legal effects concerning them, significantly affecting them, and which is to be based solely on the basis of automated processing of data. I think that solely carries a lot of weight there, and I hope we'll have the opportunity to come back later to how the idea of human engagement or review can help mitigate some of the legal challenges or risks as companies evaluate and implement AI tools. But back to the GDPR updated this language and added some additional contours, and most notably toothy penalties, which came into effect in 2018. Companies have been, in that context, thinking about what tools, including AI tools, may fall into the category of making such automated decisions. Last month, the European Commission proposed a regulation proposing harmonized rules on AI. This is a really significant development. This is called the Artificial Intelligence Act, and it has a ways to go before it is enacted or comes into effect. But the proposed penalties alone, up to 6% of global annual revenue, should encourage companies to pay attention. The regulation takes a risk-based approach, setting out unacceptable high and low risk categories based on the AI tools' contravention of, quote, union values such as fundamental rights. What I think we see here is, again, the conception of individual rights at the center of AI regulation. And we'll have to see whether this approach is adopted in the US, which has had a slightly different approach to business regulation and the administrative state more broadly. There will be a thank you email that contains the link to the client alert, and you can look for it there. Okay,
great. So that's one way to for businesses to get out ahead of some of these concerns. What are some other what are some other approaches that we're seeing out there?
Julian, if I may jump in here, probably no surprise to our listeners, this is still handled on a case-by-case basis. There are some companies that have appointed head of responsible AI or someone in a similar role. But by and large, even if the role does exist, it's really a work in progress. And that presents a great leadership opportunity for lawyers. Traditionally, a business team would identify an interesting tool, and then they would work with procurement, which in turn is supported by commercial contracting or similar transactional lawyers. In a somewhat different part of the company, you have regulatory and compliance functions, and those functions tend to answer specific questions or help with specific issues when they come up for the procurement or commercial contracting team. The structure is not ideal for dealing with AI, that, as I mentioned earlier, involves regulatory and compliance issues, and Vivek just described many of them. And a lot of these issues are either new to the company or they arise in a very different context. And note that these issues also involve ongoing governance and regulatory compliance. So for new issues, reputational risk arising from AI solutions is that compliance issue, legal, procurement, business, or PR. It's really not clear what traditional bucket it falls into. And again, as Vivek is just describing, this is a rapidly evolving area of the law that's regulated through a patchwork of laws and regulations worldwide, all doing it in a different way, either leveraging existing laws, creating new laws, or using other mechanisms. So a critical function that a lawyer working on an AI license can serve is really a brain trust. And it's a brain trust of working with a business and procurement to understand the specifics of the solution, as I was describing earlier in our conversation. Where is the machine learning component? How sophisticated is it? How would it get trained? What types of output or decisions may it produce now, or importantly, in the future? And finally, what are the relevant regulatory or reputational areas of concern? This lawyer or someone in a similar role needs to formulate and answer this wide range of questions and then analyze the input and perspectives in a way that hopefully aligns with the business objectives, but does so in a way that educates and accounts for relevant risks. Here are some potential questions to give you a sense of that role. Who in the company or perhaps outside specialists need to be consulted, and what information do they need to properly vet the solution and provide advice? What components of the analysis are reputational and operational that need to be explained to the business and taken into account to decide between various AI tools under consideration? And then determine where and how to implement the tool, how to use the tool, or importantly, how not to use it, and how to monitor it continuously, because remember, it's an evolving process that's trained on training data and then further evolving based on production data. And finally, which components are important for the contract, for example, for the purpose of allocating responsibility for compliance with laws that we were discussing earlier.
Well, Marina, you've described what is clearly a vast area that could potentially involve significant resources. Vivek, how can our clients who are in-house counsel handle this vast array of issues for AI tools? Is there a way to prioritize or triage them?
Well, as Marina mentioned, licensing and implementing AI tools can create really a range of issues that today require engagement from a range of subject matter experts. AI implementation isn't an area that companies' legal department staff are covered by dedicated AI experts. Today, it relies on IP or privacy specialists. Frankly, that may be the right approach at the moment, but over time, it may change as one way or another. Either everyone has to become an AI expert, or dedicated subject matter experts will have to emerge as a legal subspecialty. It's a role that lawyers evaluating AI tools may want to work backwards from evaluating potential risks to see how to mitigate those risks the same way they do in other contexts. One way to do that is first determine how much concern that a potential tool merits, work backwards from the ultimate purpose or use case that the business is presenting for the tool. This is a concept we see articulated in the FTC guidance, for example. And you can really see this range on a spectrum from totally innocuous to clearly discriminatory. And I think that that's something that with more time and experience, people will be able to place the use case of a particular tool more accurately on that spectrum of harm or potential risk. Are there legal risks, for example, in the Fair Credit Reporting Act or fair housing context, or are the risks more principally reputational? Are the right stakeholders involved internally, such as corporate communications and marketing, if reputational? You can't offload brand risk in a contract. I think that there's, we've seen thought leadership that really sets out some of these considerations as companies start to think through these issues. Some of the mitigations you can do are ranking, the different types of impacts that a model has, whether it's on individual rights or relationships, whether it's making decisions in a discriminatory manner or demonstrating bias. You can also look at, as Marina mentioned earlier, the quality of training data, whether you have the rights to the data, how mature the model is, and how much you can really explain the model. I think that these are all concepts that the FTC has set out that are emerging in guidance in all sorts of places. And we'll hope to see this kind of coalesce towards a more clear and concise and more extensible framework that we can hope to apply across AI tools.
I completely agree. Companies need a framework or a ranking for dealing with these issues. Today, businesses are looking to implement AI as quickly as possible, fearing that going slower is going to lead to competitive disadvantage. As I mentioned earlier, the reality is that the economic benefit of AI is not guaranteed, and it depends on many factors, of which regulatory risk is key. We, as lawyers, need to identify and explain these issues just like we're doing today, but more importantly, we need to have solutions. And creating a tiered framework that is company-specific, that's based on its general regulatory regime, for example, considerations for a company that's highly regulated, like pharmaceutical or financial services, would be very different from a manufacturer of goods. And developing this framework of likely uses of AI and related types of data, all of that preparedness allows you to move more quickly. For different organizations, again, depending on the industry, the solutions will be different. Adobe recently announced that it formed a review board that reviews new features for potential bias before they're launched. The example Adobe is concerned with is a feature to detect unauthorized purchases of Adobe software, and the fact that that could inadvertently learn to block customers of a certain demographic.
So earlier in the discussion, there was some mention of the training of AI tools and AI systems. That is, of course, the first step in using an AI system. Are there unique regulatory issues with respect to this particular aspect of AI, the training of the system? Vivek?
Yeah, I think that this is one of the areas where we see the kind of natural progression of privacy and data protection laws being one of the relevant frameworks. And I think we can see this in the context of the use of data, consents and permissions around the use of data, and how, in reality, for a lot of these AI tools, particularly machine learning models, training data is required at scale. And if that training data is identifiable, and even if it's not identifiable on its own, understanding that longitudinal data or large data sets can increase the identifiability of data, I think companies have to think really critically about what was used to train a model. What are the consents and permissions that existed around that data? Did the company that they're licensing or obtaining this tool obtain or check or review those consents? Or how did they get to a level of comfort that their level of risk acceptance is something that they are expressing contractually and really understanding when they are taking such risks? I think that this is one of those issues that ties into other broader harms and risks that need to be managed. And I think in particular, you can see this, for example, in the context of data or models that are trained on identifiable data that express bias because they're not trained on sufficiently diverse data sets. And different privacy laws in different jurisdictions can cause companies to seek to not collect data, for example, of certain populations if they view the laws of those jurisdictions to be more strict or more difficult to comply with. But a downstream result could be a biased training data set that does not accurately represent the world's population. So another aside, but I think an interesting legal point is an ongoing case between HiQ and LinkedIn in which the use of the Computer Fraud and Abuse Act is being challenged by HiQ, which allegedly scraped LinkedIn's website to obtain data to train their models. One of the principal restrictions on accessing and using data that is nominally public or semi-public in the context of platforms such as social networks are restrictions that exist in the terms of use. And the Computer Fraud and Abuse Act has been one of the primary legal tools that is used by companies that have a term of use that prevent certain use of data that's posted to prohibit other companies from scraping and using that data for their own purposes. We'll have to see where the case goes, but if the CFAA is no longer a valid tool or an effective tool to prevent such use, I think we can reasonably expect that the provenance of data used to train models is going to be an increasingly interesting question for which there may not be a specific legal answer, and there may not even be a specific legal remedy for companies that have had their data or data of their users or members or customers scraped and used to train a model. Now, just going back to Marina's point, and as I return from my digression, how to actually deal with some of these risks. You know, people talk about AI audits and people talk about validating the algorithms. Not everyone, and I think actually really few people are going to have the ability to conduct a front-to-back actual audit of underlying technology just from a capacity perspective. Because it's so hard to evaluate, I think you're going to have to look to signals, like Marina mentioned, principles or the existence of committees, and to ask and learn more about things like the charters of such committees, what they do to manage risk and bias when developing the tools.
So Julian, we covered a lot of ground today. I thought it might be helpful for our listeners if we tease out some of the main themes from today's discussion.
Sure.
I think one is we have to recognize AI as an ecosystem, right? It's broadly defined as AI, but the label is not particularly helpful unless you understand where the true machine learning elements are, how they're trained, again, what data would be used, what the intended results are. We clearly heard there's sort of a patchwork of laws, but the regulatory regime is evolving, and these issues are much broader than just negotiation of an AI license. They include brand, reputational, ESG type risks. And finally, to provide effective counseling to the business, legal groups need to have an agile and frequently assessed risk-based frameworks that help triage these issues in order to focus the efforts either on high value or high risk solutions involving the critical piece of training of the AI system and ongoing compliance.
Well, thank you very much, Marina, for that high-level summary. And thank you, Vivek, as well. Thank you both for your insights today. Listeners, if you have any questions about today's episode or anything else related to technology, transactions, and the law, particularly if you have any ideas for topics of future episodes that you'd like to hear about, please email us at techtransactions@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.